how time works out for us. We will have a hearing on Senate Bill 465. We will open up the hearing on Senate Bill 465 with an overview from our Senior Assistant Reviser, Tamara Lawrence.
Thank you, Mr. Chairman, and good morning, committee. Senate Bill 465 would amend the Agricultural Corporation provisions of law that provide the procedures to establish certain dairy production facilities and swine production facilities in Kansas. Currently, corporations, trusts, limited liability companies, limited partnerships, and corporate partnerships, with some exceptions, are required to obtain approval from a county in order to establish those facilities in that county. Last year, Attorney General Opinion 2025-21 looked at whether or not a limited liability partnership is a limited partnership that would be required to obtain county approval in order to establish a swine production facility in the county. That Attorney General Opinion opined that no, limited liability partnerships are not limited partnerships and would not be required to obtain county approval to establish that swine production facility. So Senate Bill 465 would include limited liability partnerships in the list of entities required to obtain county approval for the establishment of any such swine or dairy facilities. The bill would provide a definition for limited liability partnership on page 5 in line 22, and would also make conforming amendments to related statutes. Additionally, I would like to note that on page 10 in line 11, the words by a have been missing between county and corporation at the start of the line. They've been missing since 2012, actually. So if the committee chooses to work this bill, I would request that you consider including those words. Senate Bill 465 also makes some technical amendments to existing law and would take effect on July 1 upon publication of the statute book, and I'll be happy to answer questions.
Questions, Committee of our Reviser? Seeing none, if I may make it really simple, other than it does define limited liability partnership, the very first sentence in the documents you provided really is all the bill does. It would include limited liability partnerships as an entity required to obtain county approval to establish a dairy or swine production facility.
Correct.
And that's, committee, as simple as it gets, other than the definition. Now, I understand that it may not be that simple from the perspective of some of our conferees, and we'll see. We'll learn some things today. But I see no questions. Thank you for your information. We do have a proponent in person today, and I'm going to apologize. I know it's Kathy, I don't know if it's Sharplez, but if you would step up to the mic and then pronounce your last name, please, for the benefit of the committee so we can properly address you.
Hello. Thank you, Senator Peck, for the chance to be here. My name is Kathy Sharplaz, and I am a resident of Ottawa County, which is the county that gave rise to that Attorney General opinion that Tamara described. And that's what brought everybody's attention to the fact that there is a loophole concerning LLPs in the corporate agriculture statutes. That loophole needs to be closed, and Senate Bill 465 will do that. The statutes dealing with corporate agriculture were written for the purpose of protecting family farm operations, which are the vast majority of farms in Kansas, from takeover by outside corporations. To that end, our statutes prohibit corporations from acquiring agricultural land in Kansas, with just a few exceptions. One of those exceptions being if a corporation, one of the 5 types, and you'll see, you should have a handout that shows this little chart with a blue box. The 5 types of corporate entities listed on the left may acquire ag land in Kansas for purposes of establishing dairy or swine production facilities in a county if and only if that county specifically votes to allow it, either through a resolution by the county commissioners or through a direct vote by the voters in response to a ballot question in a county election. The second category on the right here is those that are defined in the statutes as involving a family component. These family-involved farm businesses may establish dairy and swine production facilities without any county vote. So there's a problem. As you can see, LLPs are not in either list. They're simply not mentioned in the statutes. This is an oversight that has put LLPs into a kind of legal limbo. And this loophole is a problem for reasons I'll describe. But first, we must note that that Attorney General opinion issued on September 18th of last year attempts to place LLPs into the allowed exempt category. But this category is all family-related farm businesses, and they're defined that way. LLPs are not defined as family businesses. Therefore, they don't belong in this family farm category. They appropriately belong in the other non-family businesses category, which require a county vote. To place LLPs into the family farm category, which is exempt from a county vote, is to deprive Kansans at the county level of a decision-making authority that the legislature regarded as so important that it codified that county authority in these statutes. Attorney General opinions do not have the force of law, but most ordinary citizens assume that they do. Only the legislature can amend the law to fix this LLP loophole. If the legislature does not act and the LLP loophole is not closed, then any giant corporation could simply form an LLP and then go into any of the 105 counties in Kansas and acquire land and establish dairy and swine production facilities without a county vote. Now, the overwhelming majority of Kansas counties have not voted to allow corporate swine and dairy production, but they could get stuck with it anyway because of the LLP loophole. Senate Bill 465 will protect Kansans against that scenario. It will correct the unfortunate situation created by the AG opinion. It will eliminate the confusion caused in the current gap in the statutes, and it will preserve county authority in this important matter. For these reasons, Senate Bill 465 deserves your support. And Chairman Peck, if there's time, I'd be happy to take any questions.
There is time, and we appreciate you being here. We appreciate your testimony, and so we will allow the committee at this moment to ask questions if there are questions. Senator Alley.
Thank you, Mr. Chair. I'm looking at the box that you have here, and can you tell me what a limited liability agricultural company is?
I don't have, they're all defined in statute 17-5903. That's the definition statute. I don't have them all by memory, but it's a family-based LLC, but it's called an LLAC. It's kind of like there's a limited agricultural partnership, and if you look that up in the definitions, you'll see that it has a family component. That's the one thing I remember from studying that statute is that all 8 of those entities in the category that's exempt from a county vote, they do have a family component.
Thank you.
But that's the place to find the definition. I'm sorry I don't have it by heart.
Well, we appreciate that. We can look at 17-5.
5903.
Additional questions, committee, of our conferee.
Yeah, I'm sure Tamara can direct you to whatever statutes you need.
Yes,
Anything else?
we can rely on our revisor to keep us straight. And Senator Francisco.
Thank you, Mr. Chair. I'm just wondering if we could get that information now while the conferee is still standing, and that would help if there's any follow-up.
Get what information?
I'm asking if our senior assistant revisor or research could give us the definition that's in statute.
Of the limited liability agriculture company? Yes. Okay. Do you have that? Okay, yes. Revisor Lawrence?
Thank you, Mr. Chairman. If you look on page 5 of the bill, starting in line 4, the defined term is Family Farm Limited Liability Agricultural Company, and you can see it goes from line 4 all the way to line 18 there in the bill.
Thank you. That makes it even simpler. It's right in front of us here. And that covers all of the groups that she mentioned in the box, probably. Family Farm Corporation, Authorized Family Corporation, et cetera. Well, that's 5903. Okay, that's all we need for now. Okay. Thank you for having that. Senator Shane.
Thank you, Mr. Chair. What's the fundamental difference of risk through it by any of these different company structures, which are generally utilized for tax, legal, and liability purposes? I have a number of family friends that structure their agricultural enterprises as LLCs, S Corp, C Corps, and they're still family-owned businesses. I guess what I'm struggling to understand, really, I guess, the existing law as it sits, because I'm not understanding why we discriminate just based off of how a company is organized and structured.
Good question. Very good question. If you look at in my own county, and I've studied the plat maps for my own county a lot, almost all the farmland is in LLCs and trusts. But in the eyes of the law, these are family farm LLCs and family trusts. Otherwise, they couldn't own ag land. They are, when you get down to the nitty gritty, they are family farm LLCs because they're owned by families and family corporations and family trusts. That's what's very interesting about this LLP loophole is, with one exception, I don't know of any other agricultural LLPs in the state of Kansas. Now, I haven't had time to do thorough research, but I've only heard of one. And when I talk to non-farmers about this LLP loophole, they say, wait a minute, how could LLPs be involved with farming? LLPs is a structure that you usually see for doctor and lawyer practices, for accounting and real estate firms. The whole point of an LLP is that any individual partner will not be liable for liabilities incurred by any of the other partners. So you can see why doctors and lawyers who are subject to malpractice suits, say, would want to be in an LLP, so that even if one doctor in the practice gets sued, it doesn't take the whole practice down. So that's typically where you see LLP. And frankly, an LLP for agricultural purposes strikes me as rather a strange beast. I've never heard of another one except for the one that is establishing itself in Ottawa County right now. So that's a very good question. I don't know why that particular corporation, which is a very large corporation, formed an LLP in Nebraska back in 2014. I don't know. But they're the only agricultural LLP I know of. And I suspect that might be why there was a gap in the statutes and LLPs never got mentioned. It might just be because nobody ever considered that LLPs might be involved in agriculture. So the situation has changed. Now we know for sure there is at least one LLP involved in agriculture. So, LLPs, since they are in agriculture now, they need to be defined in 5903, and they need to be categorized in one or the other of these categories. Where I disagree with the Attorney General is why they would go in the family farm category. My accountant sister has informed me that you could have family members involved in an LLP. There's nothing prohibiting it. The problem is, if you look elsewhere, Chapter 56 of the Kansas statutes about partnerships and the Limited Uniform Partnership Act, I think it is, Chapter 56A. LLPs, when you look at the definition, there is nothing about families. And what makes these categories on the right, and myself, I own land, it's in trusts, it's a family trust, and all my friends have corporations and LLCs that their farmland is in. The difference is when you look at these definitions in 5903 of these categories on the right, there is not just family involved. The family component is a requirement. And there's no such thing with LLPs or any of the other categories on the left.
Senator Shane, you have a follow-up question?
Is that clear as mud?
Yeah, I mean, I guess it gets down to how do you discriminate between them all? You know, I could envision, let's just say we'll separate from the swine industry, we'll go to the dairy industry. Two dairy farming entities, both owned by families, come together to do a joint partnership to build a new dairy together jointly, would be an LLP. Why would we functionally treat them differently than if they had just done that on their own, if they organized that dairy as an LLP?
Well, I think the key thing is the way the law is worded. An LLP, well, I would say an LLP, but any of these general corporation category cannot acquire land to establish dairy and swine production facilities. So if you've got two already existing dairies that get together, I don't see there would be any problem with that. And some families, I mean, I can think of lots of examples. There's lots of huge swine and dairy operations in Kansas that are run by families, and this wouldn't affect them. It's families can do anything they want. What the law was written back in 1981 when the 5903 and 5904 were passed, the general corporate farming law. The purpose of it was to protect family operations against takeover by outside corporations. That was the point of it. And then in 1994, 5907, the corporate dairy law, and 5908, the corporate swine law, were passed. And if you read those statutes, it's county, county, county the whole way through. The whole gist of those statutes is we will allow corporate swine and dairy production, which before that weren't allowed. We will allow it as long as the county votes to allow it. And so I see the key point here as being counties' abilities to make decisions about their own future. And I think the Attorney General opinion, if it's not corrected, would mean that counties lose that authority, because then all you have to do is form an LLP and you can come in anywhere. Even I don't know about dairy, but I know that in the case of swine, 82 counties out of the 105 have not voted to allow corporate swine production. And the reason I'm concerned about this issue is that they could get stuck with it without any vote. And what counties decide to do on their own, I've got no problem with. But I don't think something should be snuck in through the back door, so to speak, through a loophole in the law. And that's why I think the loophole needs to be closed.
Senator Shane, additional questions? Senator Alley.
Thank you, Mr. Chair. Does this prohibit one family from selling to another family?
No, not in any way.
Does it prohibit one family from selling to a LLC?
No, not as far as I don't know. I know that we've had these statutes in place for, since 1994. That's over 30 years, and there's never been any problems with that. There just was an oversight in the law where LLPs were not listed. But those laws have worked fine for 32 years. The LLP thing is a very recent a very recent development. But the laws as they are, people have been buying and selling land, setting up LLCs to run their family farms with absolutely no problems. So I don't anticipate any problems.
Saying the family farm is, if it was not a family LLC, does this prohibit an individual such as me selling my farm to a corporation?
No, I don't think.
Okay.
Well, let me think about that.
Well, we'll
Senator
get an
Peck,
answer
or maybe Tamara knows the answer to that.
we can get an answer from our revisor rather than you guess.
Yes,
with
thank you.
disrespect, but-
I can't say for sure. I just know that we haven't, as far as I know, there's been no problems with these statutes over the last 32 years. And the LLP is just a new development that needs to be included in the statute.
Additional questions, committee? Seeing none, we appreciate your testimony, appreciate you being here today and providing information for the committee.
Thank you so much, Senator.
Committee, I will direct your attention, we do have written proponent testimony from Jay Hall, Deputy Director and General Counsel, Kansas Association of Counties. We will now move to opponents. We have a couple individuals appearing in person. First up will be John Donnelly with the Kansas Farm Bureau. Mr. Donnelly, welcome to the committee.
Thank you, Mr. Chairman and members of the committee. My name is John Donnelly, and I'm here today speaking on behalf of the Kansas Farm Bureau. I'll just kind of jump into it, I guess, here. You've got my written testimony in front of you, and I think the line of questioning has been perfectly appropriate to follow along with my written testimony. I will tell you, while you guys were asking those questions, I entered the business entity search on the Kansas Secretary of State's website, and I put Farm LLP. There's 4 inactive and good standing. I put Ranch LLP. There's 2 active and in good standing. These do exist. To the Senator Shane's point, essentially this law is trying to limit the corporate structure that you can own a family farm. The other question that I think is important here, we had the question on a limited liability agricultural corporation. I would say the reason that was created, and let me back up here. This is the one statute that I've actually went back in the microfiche to 1973 to study. So I've studied this. It's been about 10 years ago when I did it, but there's a lot of discussion that went into this law. And I will say that in my opinion, this law was passed based on emotion, not on policy. And if you go back, they created limited liability agricultural corporations, but nowhere in statute does that exist, and I've never actually found a place where you can register a limited liability agricultural corporation in the state of Kansas. What I have found is when I looked up in the business entity search limited liability ag, 7 businesses were created as limited liability ag corporations. They were created as LLCs. So arguably, they probably could be argued to be illegal in the state of Kansas and should not be able to own agricultural land. I say all that to point out that this is, in my view, an unconstitutional law. I believe it's in violation of the Dormant Commerce Clause. I believe it's been in violation of the Dormant Commerce Clause since the day it was passed. However, I will also tell you that there has been no case law directly to that point in the state of Kansas or in the 10th Circuit Court of Appeals. There has been case law of similar statutes in other states, including Iowa and South Dakota, that you see referenced in my testimony. There's also the Kansas Attorney General opinions that have opined on the constitutionality of this law, and they would say that they questioned, they would not say it was unconstitutional, but they thought it was an adequate question, or a question that it could be ruled unconstitutional. There was also a report, Mr. Chairman, that was the Kansas Judicial Council. There was a committee created, and your former colleague, Representative Lance Kinzer, was the chairman of that group, and it found that this statute could violate the Constitution under the Dormant Commerce Clause. I say all that. I'm a little bit off point, but I think I have a broader point to make that will help you in your discussion of this bill. In my view, this bill makes an unconstitutional law even more unconstitutional. However, all that said, enforcement mechanisms have not been really enforced in the state of Kansas, and there's a good reason for that. If we start enforcing this law, you will see an uprising of business entities that are created in the state of Kansas to conduct agricultural business for the same reasons that Senator Shane expressed. that are for tax purposes and for liability protection purposes, and there will be an uprising, and this law will need to be repealed. I would encourage you to just get ahead of the storm and repeal the law in its entirety. With that, I'll stand for questions.
You said that in your testimony and in your written and in your verbal that 465 only makes a likely unconstitutional law worse. Okay. Right. That begs the question, why, if this is a 30-some-year-old unconstitutional law, has it not been challenged in Kansas or the 10th Circuit?
I am aware of at least one case that was filed in the Shawnee County District Court, and it was dismissed because of lack of standing. The reason there was no standing is because there was no enforcement action being taken. Essentially, the court probably correctly determined that there's actually no case or controversy in this case, so they would not do what they viewed was a declaratory judgment. It goes back to the fact that I don't think anyone is enforcing the law as it's written, which is a good thing in my view, because I do think it would cost some entity a lot of money to fight this all the way to the 10th Circuits or the United States Supreme Court or the Kansas Supreme Court. So that's my supposition. That's what I believe is occurring.
I appreciate the fact that you said the court probably got it right. A lot of cases where the court, this chair thinks, did not get it right.
Well, it was a standing issue, so I'll give them that one.
Additional questions of Mr. Donnelly? Senator Titus.
Thank you, Mr. Chair. Mr. Donnelly, when you describe the bill as unconstitutional, are you referring only to the mechanism of owning agricultural land, or are you also suggesting that it's unconstitutional to allow counties to vote on whether they would allow the swine or hog facilities to operate in their boundaries?
I think that's a great question. Arguably, you could say that it's unconstitutional on both fronts. The reason I would say that is because the vote is actually only on the ownership structure of that entity. You can have the same size swine confinement facility, the same size dairy confinement facility owned in a different manner, or by in-state folks if they qualify under the Phantom Limited Liability Agricultural Corporation or other exemptions that are in here. So I would argue that, yes, this law would be unconstitutional on all fronts. Whether the court would agree with me, I don't know.
Additional questions of Mr. Donnelly? All right, appreciate your perspective, appreciate your testimony. We do have another opponent, and this is Aaron Popelka, Vice President of Legal and Governmental Affairs, Kansas Livestock Association. Welcome to the committee.
Morning, Chairman Peck and members of the committee. I'm Aaron Popelka, Vice President of Legal and Government Affairs with the Kansas Livestock Association. Pleasure to be with you for the first time this year. We represent nearly 5,600 members all through the production chain on livestock. We concentrate a lot on the beef side, but we have dairy producers and swine producers. I want to start by giving you kind of one of our foundational policies and one of the main reasons we oppose this. And I'm going to read it because I think it's important. It says, KLA is opposed to attempts to narrow the business options or limit the individual freedom of livestock producers to innovate in the management and marketing of their production unfettered by additional government regulations. Adding another prohibited entity that any other business in this state could use to operate their business, mitigate risks, seems like it is doing just that it is limiting the individual freedoms and business options of livestock producers. Into what end? And I should also mention, too, I wanted to mention this. It's been framed that this is about dairy and swine facilities. It's actually not. If you look at page 5, line 24 through 32, that is the general prohibition. So it is not, and it says any of those entities are prohibited from owning, acquiring, leasing agricultural land. So it's not just livestock. It is all agricultural land owners. I want to make that clear. Not that limiting to swine or dairy would make this better, but I want you all to understand how broad this is. I also want to touch on the fact that the entity that started this in Ottawa County, that's a member of ours. And as this started, and I have in my written testimony, I won't get into too much, when they filed their environmental permit, which our engineers did, by the way, that's what set this off. But leading up to that, there was a significant amount of due diligence, of which I was a part of, to ensure that they were complying with this law. LLP, as it was posited by the proponent, is not a loophole, and I'll explain why it's not. But Schwartz Wilkie LLP is a family entity. It was started by two brothers. It is now in the second generation of 5 siblings. The reason it's non-compliant is not because it's not owned by a family, it's because it's a Nebraska LLP. And that is, as Mr. Donnelly pointed out, one of the reasons this is likely unconstitutional, because it discriminates against out-of-state investment, which I think, if we're a pro-business state, we want. I'd also note it was said that that a corporation could simply, under this law, start an LLP and operate if they're otherwise prohibited. That's not true. If you look at the definitions, one of the prohibited entities is a corporate partnership. And this is noted in the AG's opinion. The AG said LLPs are exempt unless they are a prohibited corporate partnership. So a corporation couldn't just start a partnership with another corporation and magically be exempt under LLP. They would be otherwise prohibited, and the AG noted that. Now, I want to touch on, first, before I depart, so Source Farms, I have in there the economic impact that they've brought to the state of Kansas. Once this is complete in Ottawa County, operating in 3 counties has substantial impact on taxes, payroll, employees, Kansas grain that's being fed. And this is a type of entity that we'd prohibit. And I also want to note, there is no grandfather clause. This is retroactive, which is another reason it's likely unconstitutional under the 5th Amendment. You can't just ban somebody from owning land and make them divest without having consequences. There is no savings clause for that. The reason this is not a loophole, if you look at history, and I cite to the bills that were done over time. So the act itself was created in the 80s, and it was touched on about the farm crisis. We can argue probably about whether it was effective or not. But at that time, LLPs and LPs didn't exist. LLPs were created in 1994. Okay? In 1998, and this is all my testimony, the legislature chose to update the LLP-LP statutes. They included in 1998 a list of entities, LLCs, LPs, but did not add LLPs. This act was again updated in 2012, and the legislature made a conscious decision not to, and there's a reason it did not to. LLPs function inherently different than an LP. An LP has a managing partner and unlimited investor-like partners that don't have day-to-day managing responsibilities. An LLP functions almost exactly like a general partnership, which is not prohibited by the Act, by the way. Just because it's not listed doesn't mean it's not prohibited. Sole proprietorships, general partners, and LLPs, even though they're not listed, are allowed to own farmland under the Act. The reason LLPs function like GPs is because they don't have those limited partners. All it does is, and it was mentioned, is it extends certain liability protections. In fact, a GP under statute can opt into an LLP structure. That is why the legislature twice made conscious efforts not to include LLP, because it doesn't function like the other corporate described entities in the statute. Last, and Mr. Donnelly touched on it, I do have in here citations to those sources that looked at the constitutionality of this law. One was then Secretary of Agriculture Dale Rodman asked Attorney General Derek Schmidt to opine on the constitutionality of the law. Attorney General said, and I'm going to quote, "He could not conceive a circumstance under which a court would find this provision to pass constitutional muster." That is the provision that explicitly prohibits out-of-state investors. That's really what the Dormant Commerce Clause is getting to. Then in 2013, again, then Secretary Dale Rodman wanted to propose to eliminate this law. This committee and the House committee jointly, because they wanted more information, asked the Kansas Judicial Council to study this. And I have in there who was on there. It was involved legislators, attorneys, and 2 constitutional law professors. And their opinion was that certain provisions were explicitly discriminatory on their face and would likely make this unconstitutional, while others could be discriminatory in practice and would depend on the facts and circumstances. And they said if the legislature chose not to repeal it in its entirety, you can read the report. There's a whole list of changes that would need to be made. So for those reasons, Mr. Chairman, we would urge the committee not to move this bill forward because it could cause unintended consequences here and prohibit an entity that other businesses in Kansas are available to. So happy to stand for any questions.
Thank you for your testimony. I think the issue here is, when does your right to own, operate, start a swine or dairy operation supersede another person's right to live somewhere in location without the stench created by a swine or dairy operation? I understand your argument, Mr. Falco, believe me, I do, and you make a strong case. So my question, when does one right supersede another right?
So I think, Mr. Chairman, we're talking about 2 different things. The Corporate Farm Act was designed to regulate who could invest and what type of entities could run agricultural businesses. What you are talking about, Mr. Chairman, deals with property rights and environmental issues. We have those statutes in place in 65-171D. It has mandatory setbacks depending on the size of the operation. It mandates environmental controls, and on swine in particular, they have certain odor control requirements that beef operations don't have. So if that is the concern, Mr. Chairman, I suggest maybe legislature look at those statutes, but not limit the ability of businesses to plan for like their transition, their taxes, how they operate. Those are very different concepts.
And I understand the setback regulations, laws, but a hog farm can put a pretty putrid odor for miles. And I'm going by personal experience of having a hog farm a mile and a half from my house in the past, and it was not pleasant. Committee, do you have, if you want to address?
Yeah, I would, well, Mr. Chairman, I'd urge you to maybe tour one of the more modern facilities. It's hard to smell them at times because they are designed better. But I'd also indicate, I as an individual, or you and I, Mr. Chairman, as partners, could build as large a swine facility as we want. This bill only gets to the type of entities that can own these. So right now, a prohibited corporation couldn't do it, but again, you or I could. So that's why I say if that's the issue, this is the wrong set of statutes to address that concern.
Committee, do you have questions of Mr. Papelka? Senator Francisco.
Thank you, Mr. Chair, and thank you for being here. What would an alternative be, or what would your reaction to be to a limited liability partnership that was a limited liability agricultural partnership that was required to be made up of family members?
Yeah, I think that, again, goes to the foundational argument I think that I and Mr. Donnelly on behalf of Farm Bureau is making, is that we shouldn't be adding limitations on agricultural businesses on how they choose to structure. We don't do that to other businesses as a general matter. Many other businesses can use LLPs, LLCs. We'd like the same treatment, so we wouldn't be in favor of that sort of a amendment.
To follow up, so why wouldn't that amendment allow more opportunities for that different structure as opposed to putting it in to prohibited or restricted?
I think it would be better than the bill itself, but it doesn't get to the foundational problems with the law itself. It would still be unconstitutional at that point.
Thank you.
Senator Bowser.
Thank you, Mr. Chairman, and thank you, Mr. Popelka, for your testimony. Very good, I think, and I tend to agree with you. I think we've got 3 decades of precedence here. The LLPs were created in '94 by the Kansas Legislature. Then again, a few years later, they strengthened the law in 1998. Then again in 2012, the legislature again reaffirmed its intent not to prohibit LLPs from owning agricultural land. We've talked about some of the legal cases here and some of the opinions of our own attorney generals. I sort of view this as a little bit of an anti-business. I think, again, I agree it discriminates against outside entities. And as you said, Mr. Popelka, I share your concern with there's no grandfather clause. We've already got LLPs in our state operating, again, potentially for over 3 decades. What would that impact be to those folks? And I think we've got the sort of the root cause of the problem here is the foundational law. But my question to you then is this, how big a problem is this? Are we seeing other lawsuits against LLPs, or is this sort of a one-off, or what are you hearing from your livestock association community? Thank you, Mr. Chairman.
Yeah, I think, we certainly have some members who would like to see this repealed. Others that I think are indifferent, because one of the exceptions in the law are for beef feedlots. So that's somewhat mitigated the reason why this probably hasn't been challenged, because there are a lot of exceptions. But I do know in terms of cases, Mr. Donnelly mentioned the one in Kansas that was decided against for procedural reasons. But if you look to the 8th Circuit, and I have it in my testimony, Nebraska's corporate farm laws were struck down by the 8th Circuit in 2006. A similar case in South Dakota, I can't remember the case or the year, I could get that to you, but it has been challenged in other circuits, and likely if it gets to the point of the 10th Circuit, there's a lot of precedents out there saying that it'd probably follow a likely path.
Senator Titus.
Thank you, Mr. Chair. Mr. Popelka, I understand all the constitutional arguments, but I feel like we're sort of dancing around, that underlying purpose in 1970 that hasn't really been addressed. Farm operations evolve. We have different tools for corporations and taxes that didn't exist. But, and please tell me if I'm wrong, but it's always been my understanding with this law is that law was put in place to protect small farmers and keep family farms from competing with farming corporations and land ownership, and to keep that land in families. And I understand maybe this whole scheme is unconstitutional, but am I missing the underlying purpose of why those statutes are there?
I think
you don't have to agree with it. I just think that's the purpose
Mr.
of it.
Said it best. It was born out of emotion of the 80s farm crisis, and I'd argue that the law has not done what it proposed it would do, and in fact, at this point, it's limiting investment in our #1 industry by limiting those out-of-state investments where maybe you have some younger producers who need some help because it is very capital intensive, but they can't access it because of these restrictions. So I'd probably argue that the act itself hasn't accomplished its stated goals. And so from just a pure policy reason, not a legal one, it might be time to go a different direction.
Thank you.
Senator Reichman.
Well, thank you very much, Mr. Chairman. And thank you. I can never pronounce your name, Popelka, or however it is. I've always had trouble with
That's pretty good.
When I'm listening to lawyers, I was on judiciary in the House and the Senate, and my head always spins. I know that a chairman talks about you got 10 lawyers, you got 13 opinions. And, And when we're dealing with these issues, we don't want to screw things up. I don't think we do. We want to make things better or correct things going on. And in your position, let's say we pass this exactly like it's written, okay? What do you see as what do you think will happen, will be the outcome if we move this forward? Thank you.
Yeah, Mr. Chair, I think the first thing would happen is Mr. Donnelly mentioned a number of LOPs currently that own land and operate. Those entities would have to make a choice. Do I challenge the constitutional law, or do I find some other entity to re-register as? So there would be a cost immediately, because they've got to decide, okay, do I register as one of these other ag companies, which, by the way, has an annual reporting requirement to it, to the Attorney General to prove you qualify, or do I choose to challenge? So that's the immediate effect. I think, and I'm guessing there's probably more LOPs that just don't have farm or ranch in their name. You are going to increase the likelihood that this law is going to get challenged if this passes, would be my guess.
If it's unconstitutional, how would that be a bad thing?
It might not be, but you'd sure cost somebody some money to challenge the law in court, which is always a concern.
I understand that, but and maybe that's the reason it hasn't been challenged in court. But I think this is a wide range and got a lot of issues, a lot of reasons why it was brought forward. But committee, any additional questions? I see none. Thank you for being here. Thank you for your testimony. Committee, I will direct your attention to additional written opposition. That comes from the Kansas Pork Association. Then we have a joint letter from the Kansas Corn Growers Association, Soybean Association, Sorghum Producers Association, and Association of Wheat Growers. With that, we will close the hearing on Senate Bill 465. We've got a few minutes here. I don't know if we have adequate time, but we at least will get started on working Senate Bill 425. And to begin with, we do have an amendment because of some of our discussion yesterday on the legislation. If that amendment would be handed out, please. And what this amendment does is a couple things, committee. One, I had brought up the fact that the grace period started there was no grace period. The penalty started the day after the registration fee was due. So I said I'd like to see, of course, I'm an insurance agent, and we always have grace period on everything, but a 15-day grace period. So this provides a 15-day grace period before the $25 late fee would kick in, and then an additional 15 days before the $50 fine would kick in. And so that is on the amendment. And then you will also notice something that looks like, oh my goodness, this is a lot of language. This just brings well, better yet, Revisor Lawrence, I'm going to let you explain the amendment, because you can get into the technical or legal part of it other than the grace period, which everyone can understand, because I can.
Thank you, Mr. Chairman. If you look on page 2 of the balloon, you'll see an insert of section 2. This would just bring in existing law. That would be KSA 22120. And this one relates to the live plant dealers and their registrations, which the department did mention in their testimony yesterday. So this would make their renewal system match the front part of the balloon, so they would also provide that 15-day grace period for these live plant dealers, the same as they do on page 1 of the balloon.
Thank you for that explanation. Committee, you have questions of that? That just makes certain that we're treating things equally in different aspects, live plant versus the seed registration fee. So I'm going to make a motion that we amend Senate Bill 425 with this balloon. Is there a second? Second by half the committee, but we'll go with Senator Bowser. Questions on the balloon, on the amendment? Senator Reichman.
Thank you very much, Mr. Chairman. My understanding is that they wanted more money fee collection to do what they have to do as they're looking over these different seed wholesalers and so on. And what you're doing with this is that before they get a fee for being late, you're giving them another 15 days after supposedly they're calling them or writing them or whatever before the fee is being assessed. Do I got the correct understanding of this, Mr. Chairman?
Senator Reichman, that would be correct. One reason is, of course, from my background, but also just the fact you can mail something in today's world 2 weeks before it's due and not arrive for a month. And so this and if a producer's, it arrives late, and we can allow, the department can determine if they want to look at the postmark, which they're not always postmarked, but that's part of the reason. But yes, it just makes it so that rather than 1 day after it's due, boom, you pay a penalty. So this just gives a little bit more grace. Additional questions? Seeing none, all in favor of the amendment, say aye. Aye. Opposed, no. Motion carries. We're back on the bill as amended. I will just mention briefly, committee, and we will provide this to you. The department did provide to me this morning information regarding the number of days late, and 0 to 29, 167, 34%, one-third are within 30 days late. And then we've got about 27% that are pay within the next 30 days, and then it goes down from there. But my point in bringing this to you, and I'll get you the information, is that we heard yesterday that it's many as 500 late filers. And so I think this legislation would incentivize those who pay the fee to pay on time, but give them a little bit of grace. Questions or what's your wishes with 425? Senator Titus.
Thank you, Mr. Chair. I move that the committee recommend Senate Bill 425 as amended favorably for passage.
There is a motion by Senator Titus, seconded by Senator Alley. Questions on the motion? Seeing none, all in favor signify by saying aye. Aye. Opposed, no. Motion carries. Committee, we will meet on Monday to consider bills that we have had a hearing on and see what the committee's desire is. And I would urge you, if you have thoughts on the bill still in committee, to come to me, or if you have amendments that you're wanting to propose, come to me. But we do have two bills in committee, 407 and the bill we heard today, 465. It may be a short meeting on Monday, but it may not. But I still do want to meet Monday that is our last day. That's the reason for it. I have nothing additional for the committee, and looks like no one else does either.